the preliminary is dealt by chapter 1 of the CPC. So before going to the chapter 1, I should throw some light on historical background of CPC. Is the screen visible for all? So the screen
Yes,
is,
sir.
yeah, visible on.
Yes, sir. Yes, sir.
Yes, yes. So in fact, if you find the background of CPC, in India, the first code on civil procedure was enacted in 1859. And that was having some lacuna because at that time the High Court, the Supreme Court was not amenable to the procedure code, and various other issues were there. So to tackle those issues, the code was replaced in 1877, and the 1877 code undergone various amendments, and suddenly in 1882 it again got replaced, and the third code came in 1882. And the 1882 code also undergone various amendments, and then the present code has come in 1908. This is the brief background of the Code of Civil Procedure, how it came into existence. The 1908 code, which is now we are following, has come into force on the first day of January 1909. Section 1(3) of the code states that it extends to the whole of India except the state of Nagaland and the tribal areas. If you find, I have given it in bold and underlined. Why? Because one should know some background fact of this. If you find the CPC text of 2019 or before, you will find that it was not applicable to the Jammu and Kashmir. But later, as you know, in 19, the scenario undergone a change and the code has been made applicable to state of Jammu and Kashmir also. So now, as on today, the code says like this, that it extends to the whole of India except the state of Nagaland and tribal areas. Sometimes in some preliminary exams, these kinds of questions also come. The CPC applies to the state of all of India, or the state don't apply to the Jammu and Kashmir and state of Nagaland or tribal areas like that. Some multiple choice questions may come. So one should need to focus on that also. So I thought I will bring this also to the notice of all. But one proviso has been added to that, telling that if the state government, the Nagaland state, or the tribal areas means here mainly the areas covered the Assam state, which is stated in the explanation. I'm not going to the details of that. So what is state is the state of Nagaland or the tribal areas. If they want, they can separately notify and extend its application. Its application means the application of the CPC to their state with sufficient modifications if required. Or it can be applied with such supplemental or incidental way also. That means if already there is a code or there is a law on this aspect, they can supplement it with this, provided they notify that this CPC will also be applicable along with the other one. So that way it can be applied. A provision has been made. If you find till date in state of Nagaland, this code has not come into force as such, because the state government did not make it like that. So in 2015, Supreme Court, in a particular case called Sri Westerly Dikhar and others versus Sri Sekaya Lungbo. In this case, they reiterated that the CPC does not apply in these areas. In this case, it dealt with some tribal areas of Assam. So it told it is not applicable in these areas, but only the spirit thereof applies. What it means by the spirit? The judgment says, if you see that's why I brought this judgment into picture. the court interpreted that in the letter it should not be applied. The CPC cannot be applied in letter in those areas where it is accepted, but in spirit it can be applied. What is the difference between application in letter and application in spirit? It means the code as such cannot be applied when the CPC itself if is accepted in the code. At the same time, the spirit of the code can be applied if they have any other rules of practice already over there. So in the case, the court's interpretation was that you cannot forcefully apply it, but you can take the spirit of the CPC there along with the rule which you have in that particular areas. Why it is so? Just I am taking you to Constitution of India, because Article 371A of the Constitution restricts the Parliament from extending any law to Nagaland regarding religious or social practices and even law relating to procedure. So the issue is there are some Naga customary law and other laws which are applicable to Nagaland. So the Constitution itself provided that the Parliament cannot extend any law to Nagaland, but at the same time, these land laws can be extended to Nagaland if the Legislative Assembly passes a resolution to that effect. So this is the spirit why the CPC says that it is not applicable to Nagaland and tribal areas. If you see some other areas also mentioned in CPC, means section 1 plus subsection 4, wherein some other areas are also dealt with, and in those areas the CPC says that the CPC can be applied along with any other rules which are already in force over there with such modifications or other incidental provisions. So as we are in Kerala, our nearby island is there, Lakshadweep. So in Lakshadweep also the same thing was there. CPC says in Lakshadweep also it can be applied along with if any other rule which is in force. So what happened in 1909 when the code came, Lakshadweep did not adopt all the provisions of the code over there, but rather they adopted some 2-3 sections of CPC at that point of time. And there was a regulation called the 1912 regulation. The name itself is 1912 regulation, and that was in force. Under that regulation, the plaints were to be presented before an Amin having jurisdiction over the suit. So, and no pleader was allowed in the court as per that regulation with the special permission of the, except with the special permission of the collector. So only if the collector permits, the pleader can be allowed in the court. That was the law which was there in Lakshadweep. But later, what happened in 1967, it was adopted, and now in Lakshadweep also the CPC is in force. So coming back to again the CPC, I should be dealing with some definitions which are very important because one should understand the basics of these definitions. So the first definition which I would like to discuss is mentioned in section 2, subsection 2, decree. You all might have heard about, and some among you might have seen also the decree. What is a decree and why I am explaining here? After explanation, you may come to understand why I have given importance to this. The plain meaning of a decree is defined as the formal expression of an adjudication. So I have given here some bold and underline, and those bold and underline you should stress on. Those are the crux of this definition. So decree means the formal expression of an adjudication, which so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. See here at 4 times I made a bold and underline. So if you see the crux of the meaning of decree, you should understand that the first and foremost part is a decree is a formal expression of an adjudication. Formal expression of an adjudication. What is adjudication and what is formal expression? Adjudication means the delivery of the court about a particular case or the decision of a court on a particular case. So the formal expression of an adjudication of a court and what that expression is doing, the expression does that it conclusively determines the rights of the parties. Conclusively determines the right of the parties. So it in the formal expression of that adjudication, the court conclusively determines the rights of the parties with regard to all of them or any of the matters in controversy in the suit. So in a suit, there can be more number of controversies involved than one, or it can be one. So whatever may be, if the court formally adjudicates their expression and it conclusively determines the rights of the parties in the matters in controversy in the suit, it can be called as a decree. So in simple terms, these are the three things which one should remember while understanding the term decree. And then it says it may be either preliminary or final. Either preliminary or final means it can be a preliminary decree or it can be a final decree. What is the difference between preliminary decree and final decree? That I would be explaining in the due course. And then again, the definition moves further, telling that it shall be deemed to include the rejection of a plaint. If you see, the definition says the decree can include the rejection of a plaint and also the determination of any question within section 144. What is section 144? It is a restitution of suit. That also I would be explaining. So it again says it can be either preliminary or final, and it can include rejection of a claim and the determination of any question under section 144. But it specifically says it shall not include any adjudication from which an appeal lies as an appeal from an order or any order of dismissal for default. What is dismissal for default? Dismissal for default means if a party who filed the claim did not appear before the court on the date kept for appearance, the court can again serve notice to appear, and if they don't appear even after repeated services, the court can dismiss the suit filed by them. So if a suit is dismissed for want of prosecution or for want of the party's appearance, it is called as dismissal for default. Okay. So an order for dismissal of default cannot be treated as a decree. One should understand. It's very important because in preliminary exams, it may come in multiple choice questions. What can include in a decree and what will not include in a decree. So if you are not thorough, it will go wrong. So you should be very thorough what can include and what cannot include. Then what else it says? Any adjudication from which an appeal lies as an appeal from an order will not also be treated as a decree. What it means? It means in the entire code, if it says that it will be an order and against this order an appeal can be filed. So if it is an order and an appeal can be filed, which is provided in the code, then that kind of adjudication also cannot be treated to be a decree. It can be treated only as an order, and against that order an appeal lies. So one should understand that these two are specifically excluded from the term decree, whereas some other things are included, like rejection of plaint, determination of any question under 144 are included. So now I would be explaining what is section 144 and what is preliminary decree and what is final decree.